There's a power of money to be made in this city, Bill. With your help.
But people must be made to understand that all these things are best kept within what I like to call the Tammany family, which is why I'm talking about an alliance between our two great organizations.
You're talking about muscle work.
That too. Muscle to match our spirit.
You own the crushers, get them to do it.
The police? Oh, no. Jesus, no. The appearance of the law must be upheld, especially while it's being broken.
100 years ago, a flour mill company in upstate New York decided to get in on a new and growing trend, which was to use human figures, photographs of human figures, in their commercial advertising. And this young lady was named Abigail, and unfortunately she was under the age of legal consent, and she was too young to enter into a contract. And the Franklin Mills Company had not asked her parents for permission, so they sued for her appearing in this advertisement under a relatively new theory of law, the right of privacy. This had been argued in a famous law review article in the Harvard Law Review by Brandeis and Warren in or about 1890. And the New York courts decided, ultimately, the New York Court of Appeals decided that New York State did not recognize a right of privacy as a matter of common law, although the legislature was always free to grant such a right. Believe it or not, after the family lost this case, there was such a thing in those days as public outrage. You don't see it today, but there was public outrage, and as a result, a statute was enacted called the New York Civil Rights Law, sections 50 and 51, which made it not only a misdemeanor, but civilly actionable for the use of someone's photograph or name in a commercial advertisement without written consent. And this statute has been used over the past 100 years. This is not only the 40th anniversary of the Kennedy assassination, it's the 100th anniversary of the New York Civil Rights Law. This statute has been used by such personalities as Johnny Carson, Cary Grant, Christy Brinkley, Woody Allen, Howard Hughes, and many other celebrities to prevent their images from being associated with products that they don't necessarily want to be associated with. And that's the way the state of the law was for about 80 years until 1993, when Random House published the book Case Closed by Gerald Posner. And this print advertising campaign had actually been preceded a couple of weeks earlier by a teaser promising to name the guilty parties in the assassination of President Kennedy. And then a week later, this ad ran in the local and national editions of the New York Times, naming 6 of the critics of the Warren Commission as being guilty of misleading the American public and making the representation that there was only one man, one gun, one inescapable conclusion about the assassination, urging readers to buy and read the book Case Closed. Robert Groden was one of the persons depicted, and he was they attributed a quote to him. I'll read it because you probably can't read it from the screen. Who killed President Kennedy? It took a combination of the CIA-controlled Cuban exiles, organized crime, and the ultra-right wing, with the support of some politically well-connected wealthy men, to pull it off. Well, Be that as it may, the problem was that Bob never said this, he never wrote it, and he had always taken the position that we need to find out who killed President Kennedy, and he had focused his work mainly on the photographic and film evidence. In fact, the History Channel seems to be rerunning The Men Who Killed Kennedy this week ad infinitum. You can see the interview that Bob did with them, in which he said, just less than a year before this advertisement, or less than a couple of years before this advertisement appeared, he said, "We need to find out. He doesn't know." So this had really been written by Harrison Livingstone, but there was no indication in the advertisement of that fact. And the problem was that Bob was coming out with his own book, competing with Posner's Case Closed, and so this gave a very erroneous impression of the nature of Bob's work and what he had to offer. The genesis of this at Random House is reflected in the following quote from Robert Loomis, who was Gerald Posner's editor. "All the conspiracy theories have undermined the public's belief in government, and that, to me, is a crime." This attitude is still prevalent in many quarters, and I believe it has a great deal to do with why we are still here discussing the case 40 years later. Posner himself had said that he thought the conspiracy theorists have made us lose faith in government. And here's another key point about the entire controversy. I think the debate over evidence in many respects is a false debate. And what we are really talking about, what we are really contending about most of the time, is our value systems and whether we want to uphold blind faith in government or whether we want to uphold the right of the public to question. So we saw some things that were wrong about this ad, not only in terms of the New York Civil Rights Law and the use of the photograph without Bob's permission, but also the misattribution of a conspiracy theory that Mr. Groden did not sponsor, did not represent. And so we brought suit under not only the New York Civil Rights Law, but also the Federal Lanham Act for making false and misleading representations concerning the nature of Bob's products and services. Not only did he have the book The Killing of a President, that was the title. He also had a companion video, The Case for Conspiracy, which he recently put out on DVD. And I commend that to your attention. These are among the best photographic and film compilations that you'll ever see about this case. And so the Lanham Act had recently been amended in 1989, not only to include false representations about one's own product, but also to make it actionable if you made false representations about someone else's product. And these were the theories that we relied upon. The Second Circuit, which is the federal appellate court in New York, had decided, and this is still good law as far as I know, that there is no measurement of what the impact on the public is concerned when an advertisement is explicitly false. You don't have to take surveys as to how it was understood. It's enough to prove falsity. This same theory had been used in a case in the same court in which Cuisine Arts and Robo Coupe were fighting over trademarks and competing advertising representations. And the United States District Court for the Southern District of New York had found this form of advertisement, accusing the other party of misleading the public, to be violative of unfair competition laws. This case occurred before the Lanham Act amendments, but undoubtedly the holding would still apply. Another court, the First Circuit, had found an allegation of blatantly misleading the public sufficiently factual to be proved true or false. So we thought that we were on reasonable grounds. And as far as the First Amendment considerations were concerned, the Second Circuit Court had held previously that movies, plays, and books are, after all, products sold in the marketplace. So some government regulation was warranted. Here in Pennsylvania, there's a famous precedent in the Third Circuit about reference to a public issue in commercial advertising, including negative comparative advertising, does not immunize false and misleading information from government regulation under the Lanham Act. That's the U.S. Healthcare versus Blue Cross of Greater Philadelphia.